This meeting is being.
So, good afternoon, everyone, and welcome to today's presentation. I wanted to give a particular thanks to Justice Annette Hortz from Manitoba, who is speaking to us today here in Nunavut about topics relating to family law that are federal in nature. So thank you, Justice Hortz, for your time. And I wanted to say also Santana and I are this afternoon, we're in Pond Inlet. So we're hoping the tech all goes well. But if there are any glitches, we hope that that won't happen. But just in case they do, that would be the reason why. So I think we can, without further ado, get started.
Yes, thank you, Rebecca. I hope that everyone can hear me. Maybe Rebecca and Santana, you could nod if you can hear me. Yes, thank you. Feel free to share your video if you'd like. It's always a little stressful to speak to little black boxes, but feel under no obligation. I'm sure many people are trying to multitask, listening to this presentation over the lunch hour and perhaps eating and answering email furiously at your desk. Thank you, Rebecca, for inviting me to participate in this professional development program. So the title that we agreed to was called Child-Focused Issues in Federal Legislation. I am a member of the Court of King's Bench in Manitoba. I sit in the family division exclusively. Prior to my appointment, I was practicing exclusively family and child protection law. And so I hope that you find this useful today. And if you don't, I am happy to try and be more useful in the future. So we're going to switch to slide 2. So specifically today, the legislation that I will be referring to is the Divorce Act, as well as an act respecting First Nations, Inuit, and Métis children, youth, and families. Generally in Manitoba, when we refer to the latter, we just talk about as the act or the federal act. So if I slip into that, that's what I'm referring to. I'm not quite sure if they're ever going to come up with a cool acronym or a new name for that that's more simplified, but that's what it is called at this point. So I'm going to start with the Divorce Act. And specifically, my focus today is on children, what has happened for them specifically. So the reality is that not much for kids has actually changed. So what the words we use, we have changed. That's the primary and effective. I recently heard Professor Rolly Thompson speaking, and what he indicated as someone who'd been doing family law for much longer than I have, that really the way you would present a case in 2024 isn't any different than in 1984. You focus on the children and their interests. We did change the words from custody to parenting, and now we talk about parenting time, decision-making responsibility, and there are provisions for contact orders. So this is generally where we would find things like step-parents, grandparents, third parties. But they did also enumerate in the amendments factors to be considered in determining best interests, but the overarching principle of best interest is the law of the land in Canada, and that hasn't changed. Probably the biggest change for kids is the mobility piece. There was finally legislation that came forward to address Gordon and Gertz. I want to be very clear at this point, just to be sure that this is my comments are focused only on the Divorce Act. If you have different territorial legislation, I am not familiar with it. I can tell you in Manitoba that we have recently seen changes. We saw changes to our provincial legislation after the Divorce Act amendments, and they have effectively been incorporated in our provincial statutes. But it's my understanding that the territorial government hasn't done that, or I'm not sure if it's coming, but the legislation and mobility for married parents who are seeking relief under the Divorce Act was an important change for children, in the sense that it provided much more guidance than Gordon and Gertz, where what we were seeing, I believe, across Canada was essentially a bit of a 50-50 split, where some kids were allowed to move, some kids were not allowed to move. And after the trial courts and the courts of appeal, you could really see a division there. So what stayed the same is essentially the prima facie best interest test. And it has been confirmed by the Supreme Court of Canada. This is the only test. And there are no presumptions in favor of either parent. I know that there were people lobbying for presumptions of shared parenting time, of equal parenting, and that is not the case. What we are concerned with is what is in the best interest of the particular children in the circumstances of that case. So I've already made reference, we're going to move on to mobility, because I believe that the changing of the words didn't change the assessment of best interest, but the mobility is interesting in the sense that it's not just about big moves, which is what most people talked about before. It imposed additional new requirements. If you want to move, I'm going to go through some specific examples, but I just want to highlight first that parents now have a present obligation to actually give notice if they're just changing their residence. If you're changing your apartment within the same building, if you are changing, moving from one house to another in the same community, the notice requirements, when it's going to be effective. And there is an opportunity where there is family violence and the court could dispense with this requirement, but the presumption is that every parent has this positive obligation. So place of residence is distinguished from relocation. So relocation, I think, is what typically we all thought about as mobility previously. We didn't bother ourselves with small changes. We certainly have talked about, I know in case management in Manitoba, about we're going to maintain the children's current residence. But that is usually reflective of concerns about the parents that one parent is going to unilaterally move children, out of the province or out of the city or town where they currently reside and create a circumstance where their present parenting time is no longer feasible. So the introduction of the notice of change in place of residence is to address just small changes, but relocation is about a much bigger change where there's going to effectively be an impact on parenting time. So this is all set out in section 16.9 with the requirements for notice, the content of the notice, and the ability for the court to provide exceptions, presumptions for when you can move and when you can't, and the court order. And also setting out additional best interest factors when you are specifically considering relocation. So this is going to bring me to my, so the additional factors for the relocation are, reasons for your relocation. So previously under Gordon and Gertz, it doesn't matter why you're moving. The question is just what's in the best interest of the children. The reality is that why someone is moving may very seriously impact on the children's best interests. Reasons of employment, can provide children with greater opportunities. So the impact of the relocation on the child, the amount of time that the child is spending with each person. So if someone, the reflected in the legislation is about substantially, what is substantially the majority as opposed to the majority parenting time, and whether or not you're actually exercising that time. So I know that we're probably all familiar with family court orders that say that a parent is entitled to specific parenting time, but it's also a question of, are you actually exercising your parenting time? We certainly see cases where one parent insists that they want to have specific parenting time set out, but then they don't, in fact, exercise that time. So looking at what time is the child actually spending with people? Compliance with the notice requirement. Did you actually provide a notice? I've heard the old adage, it's better to ask forgiveness than permission. This hasn't really been completely fleshed out. I know there's some recent case law out of Alberta where a parent moved and then was basically asking to have their relocation validated. And it hasn't been considered in Manitoba as of yet. But certainly, I think that the fact that that's in the legislation is significant. Is there a court order that already restricts your ability to relocate with the child? What is the proposal that you are making as a parent? If you're saying, I want to move with the child, what is it you're like, what are you prepared to do to demonstrate that this will not have a negative impact on your child effectively? And then otherwise your compliance with the legislation. When we are considering though these new provisions, the court is not to consider, will the parent go without the child or not? This was this is definitely something that was in Gordon and Gertz, and was certainly the subject of many court cases and appeals. And so the legislation now specifically confirms that that is not a consideration. So you should not be allowing your client to be asked. You don't have to have them put that in their affidavit material. That's not a factor that the court is entitled to consider. Sorry, if we could have the next slide. So the legislation, when it was amended, also introduced burdens of proof to show that the relocation is in the best interest of the child. So looking at whether the parents have equal time, whether one parent has the vast majority of parenting time. And in any other case, the parents having to prove whether location is just simply in the best interest of the child, looking at those factors, the general factors of best interest, but also the specific factors set out for relocation. All right, so this brings me to my first example. So the change of residence. So this is a move across town. So in this example, I've indicated the mother has majority parenting time. The father has alternate weekends. So mom is planning to move from her current house, I've said, on Poplar Street to a new home on Maple Street. The distance is 4 kilometers. What are the requirements for the mother? Well, notice under section 16.81 and 2, she must give notice in writing. She has to set out the date of the change and the address of the new place of residence. Unless there's a specific exception that says that she doesn't have to give any such notice. The reality is that we need to be always conscious of the fact that in certain instances of intimate partner violence, it may be appropriate to make an application for your client to be able to relocate without having to give notice. But the reality is that in these instances, the mother is simply going to be allowed to make that move because it's just simply a change of residence. It wouldn't be considered a relocation. The other side of this example, next slide, please, is what would be the requirements for the father to move? He has exactly the same obligations. It doesn't matter that he's only seeing his children on the weekends. He might be only seeing them for a few hours every few weeks, once a month, or he may have equal parenting time. When you're wanting to move, small moves within your community, essentially, both parents have to provide notice of the change in residence. And the idea, I believe, as I understood it, was to ensure that both parents are aware of their obligation and that they are both keeping the other parent informed of their address. All right, so then this brings me to my example of relocation. So from one town to the next. So I know that Nunavut is a vast territory with small places all over. The reality is that what might be a very significant relocation in Nunavut may not be a significant relocation in some place like Southern Ontario, even though the distance might be the same. I certainly know I practiced in Northern Manitoba for a long time. On the map, someplace might not look very far, but the practical reality is there's no method of transportation for your client to get from point A to point B, or the cost of that transportation is prohibitive. Those are significant impacts on parenting time. So in this example, the father has majority parenting time. The mother has supervised parenting time for 4 hours a week. The father has remarried and he's been offered a job in a different community, accessible by road. So I put the accessibility factor in consideration of the fact of how would they be able to move between the communities. So what are the requirements? Obviously, now we're under section 16.9, which is relocation as opposed to simple change of residence. The father has to give notice to the mother at least 60 days before the relocation. So interestingly, the change of residence doesn't have to be that far in advance. Realistically, I can't imagine a scenario actually, that's not true. I could imagine a scenario where someone is changing their place of residence. Perhaps they're moving in with a new partner and that one of the parents wants to object. But I don't really know that realistically that's going to end up in the court, because I'm not sure on what basis you would prohibit that, unless, of course, potentially, I suppose, if there was child welfare involvement because the new partner was considered a risk to the child. But that would create a whole other situation for litigation. In this instance, so the father wants to relocate. He also needs to set out, of course, the date, the address, and more importantly, it seems to me, the proposal for parenting time. Because when you're assessing the best interest and you have to assess that proposal, if you just say, well, I'm moving from Iqaluit to Ottawa, and on this day, you actually have to say, well, what is going to be the circumstance? Like, how are you going to continue to facilitate parenting time? Depending on what the parenting time arrangements are, that proposal may be, I'm going to pay to have them come back for the summer, for the winter break from school, things of that nature. The reality is that the proposal will be more or less reasonable depending on the totality of the circumstances. And similarly, in this situation, if there was a specific exception allowed not to have to give notice. So then, continuing the example, if the father gives notice as required to relocate with the child, he may move. Now, keep in mind, in this example, he had the majority of parenting time, but the mother's parenting time is supervised. He can move if he has a court order. So if the existing court order he has allows the move, that doesn't mean he doesn't have to give notice, but that certainly would be a significant change. We are seeing more and more people putting specifically in their court orders when a move has been contemplated at the time that, a party can move within a certain distance or to a specific community. And so he may also move if the mother does not object. So there is a positive obligation on the parent receiving notice to then actually do something about it. Oops, I apologize. There's forms prescribed by the regulations. I haven't included those in the material. Certainly believe that everyone's capable of going to the regs if they are trying to, you have to apply to oppose the move. And that there is no existing order prohibiting the relocation, such as an existing order that says neither parent will relocate the child. So if his court order gives him the majority of parenting time, but does not address residence or relocation, and the mother does not object, can the father move? In my view, if all of the conditions are met, the presumptions are in his favor, which we'll come to in a few minutes, then he would in fact be allowed to move. If he gave the appropriate notice, there's no court order prohibiting the move. He has, and the mother doesn't object. So my third example, I've called the mobility far, far away. So the first question I had for you to think about is, what is far, far away? I specifically didn't necessarily put in, how far is too far, because I think that is significantly impacted by the geography of where you live. What might not seem very far in Southern Ontario could be very, very far in the territories, given the inability to get from point A to point B. So in Nunavut, it seems to me that far, far away could be still within Nunavut. But in Manitoba, for example, a move from Brandon to Winnipeg wouldn't, although it's two very different cities and there would be significant changes, wouldn't necessarily, it would go back to the whole, one town to the next. It's easily drivable, there's public transportation, and all things of that. It could also mean if in Canada, across the country, or around the world. So in my example this time, the parents are sharing parenting time equally. Mom has been offered a new job with more money and greater responsibility. Dad was recently given a buyout by his company, and he's looking for new opportunities. Mom wants to relocate from Iqaluit down to Winnipeg. So the question is, what would happen in that scenario? So first, The mother must give notice to the father 60 days before the proposed move. She proposes the move to Winnipeg and suggests that the father have all extended school breaks, summer, spring break, and winter break. She proposes she will pay for the travel. Alternatively, she proposes the father also move with them to Winnipeg and they continue shared parenting. So in this instance, the father has shared parenting time, but he objects and he files his application to prevent the move. What presumption will apply? All right, so here now I've set out the section 16.9.3 sub 1, which is the burden of proof. So the parent who intends to relocate, in this case, the mother would have the burden of proof. The parents have substantially equal parenting time. So the mother must show that the relocation is in the best interest of the child. There is no presumption in favor of either of the mother to be able to relocate. She will need to be able to demonstrate that it's in the child's best interest. Under 16.93 sub 2, sorry, there's a typographical, it should say burden of proof, not burden of proof. The parent who objects to the relocation. So if the child spends the vast majority of their time with the relocating parent, then the burden shifts to the parent who's opposing the relocation. So in this instance, the father is not going to have a burden to meet. He has equal parenting time. If we went back to the earlier example where the mother had supervised parenting time, the onus would shift to her. She would have to prove that the relocation would not be in the child's best interest. And then we look back at 16.9.2.1 for what are those factors to look at. So in this example, the reason for the relocation is employment. The impact on the child. Well, depending on the age of the child, I've sort of put some suggestions here of possible changes. The change of school, if you have a young child, changes of daycare, the social circle, and really, where is the family? I thought of this particularly in the context if if you're living in the territory and your family is all in another part of the country and you're moving to that part of the country, it may be in the child's best interest to focus on that opportunity to facilitate relationships with grandparents, aunts and uncles. So the amount of time the child is spending with each parent. So again, in this example, the parents have equal parenting time. It seems to me that in a shared or equal parenting time situation, it's going to be very difficult to relocate. But as opposed to perhaps parents who's not really seeing their children at all, if the proposal is, I'm going to facilitate contact or parenting time for you at my cost, and it's going to be equal to or equivalent to the parenting time you're currently exercising, it seems as a relocating parent, you've got a much better chance of, if the matter's in court, of being allowed to relocate. What does your court order say about specific geographic area the child is to reside? Does your order say you're supposed to stay in Nunavut? Does your order say that you're supposed to stay in Iqaluit? So I think that these are interesting things that you need to think about, not just 5 years after you've helped your client reach a final order. You need to sort of think about these things. And I know that in northern parts of the country where parties are somewhat more likely to relocate, it's perhaps a conversation that's worth having at the front end about how we're going to navigate this for the future. So then what I've just sort of at the end of the example said, when parents have, as I've already said, the shared parenting time, and they're actually exercising that parenting time, there will be a significant impact on the child. And the legislation is drafted in such a way that suggests that that the request for relocation of a child will be an onerous burden in those circumstances. So what should you consider if you are the moving parent? Focus on what are the benefits to the child. What are the downsides of moving or not moving? Not will you go without your child, but what is going to be the impact on the child if you are not allowed to move, and if you are allowed to move. And I think that they're the same considerations if you're trying to oppose a move. And ultimately, the overarching decision for the court is what's in the best interest. So I think you have to frame the move from the perspective of the child. All right, so moving away from relocation, perhaps I'm not sure. I've sort of forgotten. We didn't really discuss this, Rebecca. If anyone has a question, I don't know that we have a chat, but if you want to just save them till the end, we can have some time for that then. So it seems to me
we don't have any. Sorry to interrupt. We don't have any questions right now, but I'll monitor it.
Thank you. So the other significant incorporation into the amendments to the Divorce Act was focus on factors related to family violence. The court has always considered all factors as they relate to the child, but the legislation now specifically has incorporated reference to family violence. And depending on who you talk to, some people think that it's gone further than it needs to. Some people don't think it's gone far enough. But the important thing is that there has been this incorporation into the legislation of a recognition of that family violence is a real thing and that it can have a significant impact on children. So section 16(3)J, when you're considering best interest, what is the ability and willingness of any person who's engaged in family violence to care and meet the needs of the child, and the appropriateness of making an order that requires persons to cooperate, and what are their abilities to do that? Oh, sorry. So the factors relating to family violence in section 16(4), the nature and seriousness and frequency of the violence, when it occurred, whether there's a pattern of coercive and controlling behavior. Certainly historically, there's been a general acceptance that physical violence, obvious assaults, assaultive behavior has been the most evident before the court. I imagine largely because it's the most likely to be reported to authorities and to be documented perhaps with medical evidence. But we certainly, I hope, are continuing to evolve and have evolved as a society to recognize that a person can be controlled and coerced to be cooperative with a partner without there being any element of physical violence, and that still is a form of family violence between partners, and it can have a significant impact on children. There is provision here that whether or not the violence is directed toward the child, or whether the child is directly or indirectly exposed to family violence, and the physical, emotional, and psychological harm or risk to the child. The remaining factors, any compromise to the safety of the child or other family members, whether the family violence causes the child or family members to fear for their own safety, for that of another person, steps taken to by the person engaging in violence to prevent further violence. So seeing evidence of, therapy, counseling, informational programs, and any other relevant factor. So focusing in on the factors some more, our understanding of family violence has changed. Our understanding of the impact of the violence in the home on children, even when it's not directed to them, has changed. I have provided some suggestions of different reading and information listening that you can provide or you can explore. I think that the recent case from the British Columbia Court of Appeal, where it was found that it was an error or not an error, that the trial judge had failed to consider that even though the children were not themselves the direct victim of the family violence in that case, but that there should be an expectation that family violence happening in your home does impact on you, and that should be reflected. And so it's not going to be good enough to say, yes, I beat my partner, but I didn't beat my children. Yes, I threatened my partner, but I didn't threaten my children. The fact that you're doing that has an impact on your children and should be considered by the court in assessing particularly the factors with respect to family violence. And that is so, and it's not going to be sort of a defense that I've certainly seen repeatedly, well, yes, our relationship was bad, and I acknowledged that my bad behavior, but it was only directed towards her or him and not the children. And so this is an important change. So so that's sort of where I wanted to point you to with respect to the Divorce Act. So then the Act Respecting First Nations, Inuit, and Métis Children, Youth, and Families. This is the sort of first of its nature federal child welfare legislation. Indigenous children, as you will probably all be well aware, have been caught in the middle between federal funding and provincially regulated child welfare systems. I have had them described to me as the modern day residential school, the impact of child welfare system on Indigenous children. So this legislation finally recognized the rights of Indigenous children and their families and the obligations of Canada under the United Nations Declaration on the Rights of Indigenous People. And it has now been upheld as constitutionally valid by the Supreme Court of Canada earlier this year. The Supreme Court has described in that case the dominant purpose of the legislation is the well-being of Indigenous children, youth, and families by promoting delivery of culturally appropriate child, youth, and family services, and in doing so advance the process of reconciliation with Indigenous people. So it's very interesting in the sense of the division of powers. The province cannot just impose their provincially and territorially determined standards, that this is a protection for Indigenous children and youth. So I thought about how you may want to consider ensuring that the Act is applied in your jurisdiction and how you would use it. I think it's important that you make sure that the particular justice that you are or judge that you're appearing before is aware of the legislation, that they've considered it. Certainly, we've had lots of cases coming in Manitoba where this has been a key issue. And it is a shift with respect to a number of issues, but I will come to those. But the focus on this legislation is different than child welfare legislation. This legislation says it's always about the best interest, even when you're considering needed protection. For example, the Manitoba legislation says we only talk about best interests after we found that a child is in need of protection. But for Indigenous children, it's a broader expectation. The Supreme Court talked about the metaphor of braiding the legislation together. So this legislation is not in isolation. You have to sort of how you your local legislation still has to be considered, but it's important to remind the court about cultural continuity, the factors to consider in determining best interests of Indigenous children, and ensuring that your child welfare agency, when you're in discussions with them about possible resolution, is providing services consistent with the legislation to ensure that Indigenous children are receiving the benefits to which they are entitled. All right, so I think that one of the most important things is about placement of Indigenous children. I am not going to speak to what's been happening, obviously, in Nunavut, but I can tell you, having practiced in northern Manitoba, that it was not uncommon for an Indigenous child to be removed from their home on reserve and then immediately taken to a community for a foster placement that was outside of their community, not with family, and not culturally appropriate. I have had cases where out of Flin Flon, where children were placed in southeastern Manitoba, so some 10 to 12 hours from their parents, with parents who have no ability to travel and no facilitation by the agency for ongoing access. And this legislation specifically says that that's just not good enough, and that we need to ensure that these children are being placed, if they're not with their parents, then first with family, then in staying in their community. And I think that this has been perhaps one of the longest battles, is keeping kids with their community. And I think that that's largely why those who have suggested that this was the current residential school system are looking at it from that perspective. Because if we're still removing children from their homes, their communities, and their culture, we haven't changed what we're doing. We're just doing it with a different mechanism in place. So I think that the next slide. So this legislation allows for the first time recognition of the laws of the Indigenous group, community, or people, and that it has the force of federal law, which means that when it is inconsistent with your territorial legislation, it prevails. I think that this is something that we have to work to reconcile and be conscious of in the priorities in considering best interests. And this applies to all Indigenous children. The legislation talks about self-identification, so it's not going to be, it's just so important to recognize that there is now in place this legislation. This is a significant tool in facilitating and ensuring that we are not continuing to perpetuate. So I think it's essential that when the Supreme Court said that this is part of the process of reconciliation, that that's what we're really talking about, is keeping children, if not in their immediate parents' care, and continuing to facilitate their culture and their relationships and their family in a way that has not been traditionally the case under traditional child welfare. I didn't go through the balance of the legislation. It's a lot more procedural, but certainly it's not a complicated piece of legislation. But it seems to me that the significant pieces are the best interest, the placement, and the fact that now we're going to be seeing more and more communities coming forward with their own legislation that's going to need to be given priority over provincial legislation with respect to assessments even of what is a child in need of protection. So I appreciate that I probably talk really fast. I think that I've managed to come in just under the actual time that Rebecca and I talked about, how long I was supposed to talk to you today. So I'm happy to have any questions, any comments, any discussion about the sort of the topics that we've touched on today, or you know, I'm happy to talk about other family law issues as long as they're not too specific to your territorial legislation. As I've already disclosed, I'm not familiar with it. So
well, thank you so much, Justice Forrest, for your talk. And it really does resonate. As I said, we're up here in Pond Inlet today talking to community members, and you know, the issue, for example, that you spoke of last with respect to children being removed from a community and taken far away, and the protective scenario is very resonant. So I just wanted to confirm that your experience in Flin Flon is connected to experiences that we're hearing about in other places. Were there questions that people had? Looks like Sarah. Yeah.
Go ahead.
I don't think we can hear you, Sarah.
She hasn't started talking. Oh, no, I can't hear.
You can't hear yet. Are you on mute?
You don't
Looks
appear
like
to
you're
be
on
on
mute.
Oh, you're back on mute. You're off mute, but I don't know why we can't hear you.
Could you write your question in the chat?
Perfect.
Okay. Thank you.
There's always tech issues at some point.
Yeah. So as we're waiting, do we have any other questions? We can take one question first, and then when that one is finished being typed, we can get to it.
So I didn't say this in the presentation, but just to remember that, of course, the Divorce Act only applies if parties are married. And so my understanding, I had recently had a statistical presentation that there's a lot of common law couples in the territory. So you're still stuck, as I understand it, with the old law.
Yes. So I see the question. I'll just read it out to you just so we can hear it. From Sarah, I'm curious to know who challenged the legislation with the long name and on what basis and how the Supreme Court of Canada ruled.
So the challenge in the Supreme Court was initiated by the government of Quebec. And so their basis of their challenge was that this legislation was ultra vires the federal government. And so the case itself is quite long. Like most Supreme Court of Canada cases. So it essentially, the Supreme Court focused on the United Nations Declaration on the Rights of Indigenous People, the federal government's responsibility for Indians under the Constitution, and the obligation for reconciliation. And their judgment is much more articulate than that, but essentially they have said that this was appropriate legislation, considering all those responsibilities. It's not ultra vires, it's constitutional. And so that was, and it was essentially something that everyone everywhere was waiting to see what was going to happen, so that they knew whether this legislation was going to continue to be an important component of child welfare decisions in Canada. And so it will be, as a result of that decision.
Great, thank you. Are there any other questions?
I do believe, I think Sarah is typing.
Looks like we might have another one. Oh, she
And
said, thank you.
Jean-Claude.
I will read the decision. Thank you. And Jean-Claude, you had a question, or?
Yes, I've got one. So is there any obligation to disclose the financial statement of a corporation if in a separation agreement, when they do not live together and the corporation have been founded after they decided not to live together anymore?
So the requirements for financial disclosure are set out within the child support guidelines, and there are specific requirements where your income is derived from a corporation to disclose that information. So the fact that if the parties did not have children and this was be an asset after their relationship ended, I'm not sure that the grounding for that request for that disclosure, but certainly as long as you have children for which support is payable, all sources of your income, whether they be corporate or otherwise, would continue to be relevant and should be disclosed. I suppose if you were about to incorporate, you've separated, and there's a claim for spousal support, your personal income tax shows that you're not making anything, and you're the sole shareholder. I certainly could understand, and I would tend to lean towards an obligation to disclose. But it would really be dependent on the facts. But certainly the child support guidelines refer to disclosure of corporate income.
Thank you very much.
You're very welcome. Are there any other questions? No? Well, thank you very much for the opportunity of presenting to you today. I hope that it was useful. Certainly, I hope that you can keep the PowerPoint and distribute it. Obviously, it's sort of my thoughts on the legislation, but it does refer to specific sections. So it's sort of a bit, I tried to craft it from the perspective of making it almost as a short reference, so that when you're going to the legislation, you can have some place to start. So I hope it's useful to you. And I have tremendous respect for everyone who practices in the far north. I think that it's much underserved, and I applaud all of you for your commitment to providing legal services in the north. So thank you again for the opportunity to speak to you today.
And thank you, Justice Horse. It's wonderful that you were able to take your time to provide us with this continuing legal education. The law side of none of it, of course, doesn't pay our speakers, but there will be swag. So get excited. You will have some Arctic swag. So thank you again for doing this, and thanks everyone for attending, and keep an eye on our website for the other upcoming CLEs that we have. Thanks again, and enjoy the rest of your day.
Bye-bye. Thank you.
Thank you. Bye.